So let's start with the basics. What is the purpose of a will? So really, at the end of the day, it controls the distribution of the estate. It says Bobby, Susie are going to get 45% of the estate each, and perhaps you're going to leave another 10% for your favorite charity or some other cause. Um, it also talks about who the guardian is for your children if they're of that age, or needs and requirements. You'll choose, it basically indicates who the executor is going to be and potentially who the backup executor is, etc. And we'll talk a little bit about that in a moment. It gives the personal representative or the executor the necessary powers to administer the will on your behalf. It protects the inheritance from family property claims, and potentially could have some tax planning strategies within the will itself. So there's three types of power of attorneys that you can have. The first one is not as used as much, and that's largely because technology has been able to allow you to do a lot of things that you required people to write checks on or be in front of them. It's called the non-continuing power of attorney, and it's used for specific situations and for a specific period of time. Say you left the country or some other thing, you want to take a leave of absence, someone could sign on your behalf. So that's called a non-continuing. And again, due to the technology now, but not used as it used to be in the past. Then there's the continuing power of attorney. This one is the one that authorizes another person to act on your behalf in financial matters when you become mentally or physically incompetent. And then finally, the third one, and this one's a bit overlooked, is the power of attorney of healthcare. And that's someone who's making the health decisions on your behalf if you become incapacitated, and it also includes organ donation issues. So a lot of us have put in, I don't know if anyone, but when you put down your organ donations on your license, it'll ask you, would you like to do donations in that? That's not the final call. Your family can still override those wishes when it comes to that time if you are doing any of those organ donations. So it's something to keep in mind when you're doing this, to make sure that that's communicated, number one, to the power of attorney of healthcare, as well as maybe to your family member. So something to consider. So let's talk about what we're here for today. The exciting topic of what an executor does. So what is an executor? At the end of the day, you're the administrator of the estate. You are accountable to the beneficiaries, but I also put in there as well as the creditors. And I've put in asterisks is you're legally responsible for the resolution of the estate. And I'll tell you why that's in bolded there, because a lot of people, when you're told you're the executor, we're usually an executor once or twice in our lives. You're never mastering this skill set. So it's a really interesting piece. And as we go through this, for those that are executors in the audience, we'll see how exciting this might be for you. So being an executor takes a lot of time, energy, and careful attention to detail. I put that because this isn't something that you can do in a few hours. It's not something that you could fly in for a day and you're taking care of all the estate. It does take some time. There's a number of people that you'll have to meet. There's institutions that will have to authorize certain things. So it does take a lot of time, energy, and attention to detail, because you're going to be documenting a lot of the pieces when you're administering the estate. Can you seek assistance? Absolutely. Now you can delegate some of the work to friends, family members, funeral home director, financial advisors, accountants, lawyers, and other professionals. But keep in mind, again, as I put in that asterisk in the slide prior, you're legally responsible for that. So choose wisely who you're going to be dealing with. And more importantly, hopefully throughout this, try to be proactive in choosing who's going to be helped. So how difficult is it to be an executor? Well, that depends on a number of factors, and here's just a few. How many beneficiaries are there? And are they all attainable, easily attainable? Did the deceased own a business or farm at the time of death? I mention that because as the executor, you need to ensure that the business or the farm is thriving just as well as when they were alive. So that's really important. If you don't have the skill set, you may have to get someone to look after that on your behalf or on behalf of the estate. Did the deceased have numerous scattered accounts? So if things are scattered all over the place, it may take additional time to make sure that those things are administered properly. It could mean that you might not be able to find some of the documents. So it could delay some factors. And I'll tell you why delaying sometimes on the administration can be a bit of a pain. Did the deceased have tax filing issues? And when you're ill and not feeling well, the last thing on your mind is, I need to file my taxes. So as the executor, you need to ensure that those are filed. Does the will have one or more trusts? In the last little bit, there's been some changes to the trusts through the government. And so you want to ensure that those trusts are still doing what you want them to do on your behalf or on behalf of your estate. And then there's the last one. If the will is challenged by someone who feels wrong, anyone can challenge the will. And just as a stat, roughly 28% of all estates end up in court. And when we're interactive and we could see each other and we'd be in a crowd, I'd ask the audience, what do you think the number one reason is for litigation in the first place? And most people throw out, greedy, this, that kind of stuff, all the really bad pieces of a human being. But it actually is a simpler one, and it's communication. It's people who thought something was going to happen because the will is at a very high level, and the executor needs to now break that down into individual tasks thereafter. So it can be somewhat confusing, and if these wishes haven't been communicated, sometimes it can lead to, again, that idea of going to court and litigating. So something to keep in mind on that. In fact, they now actually have the ability, you can buy insurance for the executor if you feel that there would be litigation on your passing. So crazy times, we're becoming more American. First steps that you would take as the executor. These aren't necessarily the most important. These are some of the first steps that you would do. The first one obviously would be to locate and review the last will. Why? Because that's going to identify who the executor is, and you want to make sure that administration is done quickly and effectively. Organ donations, they have a limited time. So you want to make sure that the instructions on the organ donations is enacted on, hopefully. Again, keep in mind that families can override that, so you want to communicate that in advance. And also the instructions regarding the funeral, obviously more important as well. You're going to have to obtain a number of death certificates because you'll be utilizing those at different institutions when you're trying to administer. You're going to arrange the care for pets. That's sometimes overlooked, but as we get older, sometimes pets become more interesting than humans. I put in there farm. Again, it's that idea of the business and the farm need to thrive the same way as if the person was alive. So you'll have to arrange for care of the livestock, crops, etc., if that is the case. In fact, Big Financial will be sending each of you what we call the executor duty checklist after the presentation, so that you have a detailed checklist of pretty much all the duties that an executor would require to be done on an estate. So it's quite thorough. We'll talk about it a little bit more in detail as we go through this, but if you've got chicken scratch writing like myself, it's PDF fillable, which means you can type in on the document of things that you were doing as the executor, because you do want to ensure that this is documented, especially if you're challenged by family members or litigation comes about. You want to make sure that you've documented all the things, when it was done, who did it, etc. And this checklist allows you to do that. Is probate required? I'm often asked that. And let's start with, first off, what is probate? And this is when you go to the court, you take the will, and the court confirms that you have the executive authority to administer and distribute a deceased estate. And they issue what is called a certificate of appointment. And it looks something like this. That's what a certificate of appointment, so very official. And it basically validates you when you're dealing with different institutions that you have the right to administer the estate on their behalf. So is it required? Not all the time, but most of the time it is. So if there's possible litigation, you want to probate. If real property is to be transferred, you'll need to probate. If there are assets over a certain amount at a bank, trust, or credit union, etc., each of them has a certain amount that they'll distribute if you have not probated the will. And it actually isn't just at the bank, trust, and corporate level. It's actually done at the branch level. And I'll share a little bit of a discussion about how my own experience with that, I dealt with it. It can be quite confusing. And of course, even though Canada savings bonds are a lot less popular than they used to be, if they're over a certain value, you would have to probate as well. Those are some of the reasons why you would probate. Now, there was a change in probate. I'm sure, all of you were excited to read this in the paper when it came about and the new Tax Act came about. As Canadians, we're very proud that unlike the Americans, we're not taxed on our estates. But in fact, that has changed since 2015, and we will officially call in Ontario only at the moment, and it's an estate administration tax. So probate was a nice way to say it's just a fee that you're charging, but now Ontario recognizes as what it is, and that is a tax. No longer do you report this to the Attorney General. You would actually do this at the Ministry of Finance, who desperately needs those dollars. Let's talk about the process on what you would do. So upon death, you would then apply for a state trustee at the Superior Court of Justice. Once you've applied, there's a turnaround time, and each community is different as far as those timings are. But eventually you'll get what we just talked about, which is the certificate of appointment. Once you receive that, you have 180 days to complete the estate information return. And I'll go into detail on what that is, but it's a new form that needs to be filled out, and you have 180 days to complete it. It was recently 90 days to complete. And after getting lots of complaints and people not being able to comply within that short time frame, they've now extended it to 180 days as of January 1st, 2020. So once you've done that return and you're dealing and administrating the estate, within a year, you usually, if it's a simple estate, you'll usually wrap it up. Keep in mind that you can be audited by both Ontario and the federal government for up to 4 years. So the changes in there with respects to the paying the tax and filling out the form. The government has hired a number of additional administrators to make sure that you are playing by the rules, that you're not hiding anything from them when it comes to claiming things on the estate. Now, if you're not going to comply to the 180-day turnaround and you are trying to do some, side things that the government thinks, and this is why they've incorporated it. The government incorporated this new act because they felt people were not acknowledging what truly the value of their estates was, that there was much money left on the side that was basically sidetracking things. And so they brought this about to ensure that none of these side deals or no claims were being done. So if you don't comply, a number of things could potentially happen. So the first thing is you could face a fine of $1,000 or up to twice the tax payable on the estate. Number two, imprisonment of not more than 2 years. And if you're really bad and you don't want to comply, both of those things could apply to you as the executor. So the Ontario government has added additional people and are really starting to scrutinize some of the estates now. Now, I've tried to get information as to how many people have been caught, have they got additional revenue from it and that, and so far I haven't been able to get any stats, but I would doubt that they're looking at every single estate, but they are doing spot checks on the estate to ensure that people are complying to this new rule. This is what the estate information return looks like. You can actually find this on the Ontario website. It's got the estate information guide information, as well as the forms that would be required to be filled out within that 180 days and then filed to the Ministry of Finance. So what's included in this? This is very high level, but all property must be listed Household contents are jewelry, bank accounts, investment accounts at all financial institutions, vehicles and vessels, including motorcycles, ATVs, etc. Principal resident in all properties in Ontario. Used to be able to use MPAC. That is not enough now. You now need to get a professional evaluator, not only for your residence, but for all your goods. Business interests, copyrights, patents, trademarks, loan receivables, those would be included in there as well. Again, what you wouldn't include are property outside of Ontario. When it's outside of Ontario, you would have to do a separate filing, whether that includes your Florida or Arizona property that we used to be able to go and enjoy at this time of the year, or other areas in the world. Assets jointly owned with another person and passed by survivorship, that would also be excluded because it bypasses the estate. And other things like RSPs, RIFs, TFSAs that have a named beneficiary, those would also not be included. Life insurance with a named beneficiary, again, emphasizing the named beneficiary on these pieces, and CPP death benefit. So most estates will be affected by the passing of the second spouse. So let's talk about that additional change. As of April 11th, Ontario Ford government released their first budget. And in that, they thought that maybe there should be some relief on this estate tax. So effective January 1st of 2020, they brought out that the estate administration tax would not be payable on the first $50,000 of an estate's value. What does that amount to? A whopping $250 in savings. So not a huge amount of money, but it's a few bucks in the pocket. They're also currently looking at relieving some additional tax burden going forward. So let's look at how much could an estate valuation be currently. So let's look at a $1.5 million estate. So what we're not doing now is paying on any money on the first 50,000. So we're saving that first bit of money, $250, as I mentioned. But thereafter, after the $50,000, you're paying $15 on each $1,000, which in this case, for a $1.5 million estate, you're looking at about $21,750 in what used to be called a probate fee. Now it's called your estate administration tax. And just as an FYI, that would be now payable to the Ministry of Finance. So final thoughts on this process. Executor duties or estate trustee duties have become a little bit more onerous. There's been a number of additional administrative costs with respects to legal, executor fees, because it's taken a little bit more time, a few more people to talk to, a few more forms to fill out. There's accounting. And again, as I mentioned, you now have to get professional evaluators to audit your estate and appraise that. Now, this could lead to some potential delays. And with that, the government does have 4 years to audit you as well. And if they learn of new information after the 4 years, currently, they could also come and approach the executor. If someone's bragging at the bar how we, bypass the government in paying fees or taxes, they can actually come after you even after the 4 years right now. Unlike the federal government, they would issue you a certificate saying all taxes have been paid. So keep that in mind. The benefits of not probating. So we talked about, in most cases, you would have to probate. But if you don't have to probate, what does it do for you? Well, it saves the probate fees, number one, or now called the estate tax. You are not required to complete that form within the 180 days. It does speed up the distributions, keeping the beneficiaries happy and the creditors. And more importantly, in a world that has become a lot less private, it keeps bequests private, which can be important for some people. Once you probate, that information becomes public. Anyone can file and find out. Actually, something interesting in Florida and California, they are now introducing electronic wills, and in fact, BC is now looking at electronic wills. So you'll be actually, be able to go online at some point, you know, pay the $15 or $30 administration fee to get the information on whoever state you want, and it shows up on your computer. So it's crazy how the world's quickly moving in those speed of direction. So I like to say that when you're doing an estate, run it like a small business. Make sure that you get, you could go into the dollar stores, buy one of those small little plastic file folders, keep everything in one place, and put different tabs on there. And some of the tabs that I would recommend when you're doing the filing for an estate is you want to make sure that you're tracking all correspondence, assets, debits, or sorry, debts. You want to have your application for probate in there, your timesheets, because there is an opportunity to get compensated as being the executor, but also for the people that if you have outsourced that or the workload, you want to make sure that they're also compensated appropriately, and you're tracking that for the beneficiaries if they request that information. Income tax, accounting records, etc. Everything would be kept in that one place, and that would, if you get audited or anything like that, you've got everything in one place. Now, a topic that used to be nothing has become something very important. As I mentioned about electronic wills, we also have these things called digital assets and reward programs. So a lot of people nowadays are doing online banking, investing, shopping, gambling, gaming. We're stuck in our houses now, so we're looking for that kind of interaction, and some of those things are starting to become quite apparent. So you want to make sure that as the executor, you're looking at those possible assets or liabilities to the estate. All digital assets must be secured, as identity theft is on the rise as well. So you want to make sure that you have those passcodes, etc., so that you can get off there. You want to make sure that you close your Facebook accounts and things like that. Things that we don't think about that are really important. Personal property. I joke with my kids, they've got probably thousands of dollars on those iTunes accounts. So what's going to happen with all that music? Digital photos. Think about it. When was the last time you actually printed a photograph? And are those digital photos important to your loved ones? And the answer would be probably yes. So how do you attain those? And then sometimes reward points. I don't know about yourselves, but I certainly plan to use a lot of the points when I'm retired. Looking forward, actually, officially next year, I become 55 and I get to do the senior day at Shoppers Drug Mart. So I'll be popping up my reward points in there and living the good life with my reward points. But on a serious note, they really can add up. And thousands of dollars are sitting there that could be transferred potentially to your loved ones as well. So look into that. Make sure that the points cards that you have, are they able to be moved to any beneficiaries on that? My one funny in this whole presentation, guys, is the little cartoon on your right-hand side. This is a nephew, obviously not the favorite nephew, but the poor guy was left the uncle's 27 Twitter followers. So that was his inheritance. That's one of my only funnies, guys. Do I have to act as an executor? So knowing how exciting it is to be an executor, do you have to? And the answer is blankly no. You can decline immediately. Now, if you decide to acknowledge that you want to be it and you decide, I can't handle this, I need to resign, this unfortunately, now you have to go to get the permission from the court. You are liable for all the things that you did prior to that. And if there's any additional delays, it could create a big mess for you. So again, this is something to consider when you're doing your wills and that and assigning someone to be your executor. Make sure you have the conversation with that individual, because they could say no. It's also one of the reasons you want to have backup executors in your will, because if those people say no, then there's a potential that the Ontario government, if no one wants to be the executor, the Ontario government would appoint one. And that probably may not be in the best interest of everyone. So something to keep in mind as you're assigning the executor in your will, you have that backup. Now, I'm also asked about could I have a co-executor? You know, I don't want to favor one of the kids, so I'm going to pick both kids to be the executors. As you're deciding something like that, just keep in mind, how are the holidays? Do they get along all the time? Do they agree with each other? Because you could be creating a big mess for yourselves. So just keep in mind as you're thinking about who do I pick to be executor, you want to make sure you've given a lot of thought to it and you've communicated that information. So does an executor get compensated? Knowing that there's quite a bit of responsibility, number one, but it's going to take a lot of time and energy. You're going to have to do some, logging of hours and who you're interacting with. There's a lot of work in there. And yes, some simple things like expenses, etc., that are incurred, photocopies, postage stamps, long distance phone calls, gas to get here and there. All those things can be easily expensed. You want to track it, of course. You don't want to get crazy on it. Sometimes the will state an executor fee. Now, given that they thought everything would go well, sometimes that fee may not be reasonable, and sometimes it may be too much. If the will does not list a fee, the fair and reasonable allowance, and that can be up to 5% of the gross value of the estate. Now, if you're outsourcing a lot of this responsibility, etc., a lot harder for you to justify that you alone should get that 5% of the gross commission. And keep in mind that it can be challenged by the beneficiaries as well. If there's no agreement on what you should be paid, the courts would decide what is fair compensation to the executor. Now, going through all that as well, keep in mind that anything that is earned by the executor is taxable at your income rate. I usually get a few groans when I'm in an audience about that as well. Taxed again. So let's talk about the first step in distributing the assets. So before you distribute the estate among the beneficiaries, you must give them an accounting of your administration of the estate. So again, I was talking about the documentation. You want to make sure either you're working with an accountant or a tax specialist, or you're doing it on your own, that you've got everything accounted for. And you're going to then prepare what is called a final statement of assets, debts, income, expenses, and distribution amounts. That statement is for the beneficiaries to then approve. Hopefully, once everything is approved, you can also put in there about your executor fees that you're charging and ensure that they would approve that. The final step, once everyone's signed off and all the debts and taxes have been paid, all claims against the estate have been satisfied, and the accounts have been approved by the beneficiaries, you can then distribute that estate. So then, does your duty end? And the answer is sometimes. And the majority of times it would. Not all estates are difficult to do, but there are times when you may be recalled in. You thought everything was signed off, but you may be called in to be an executor again for that same estate. And that's when, if assets or debts turns up years and later, you may be still legally responsible for dealing with some of them. I'll share one story, just not a terrible story, but a story of myself when we had to reopen our own estate for my father. So knowing all these exciting things that can happen to an estate, why is it that we don't plan for an estate, especially during a pandemic when we don't have a lot to do? Well, they're emotional blocks, and we all have them. No one wants to face mortality. No one likes giving up control at all. Communication with children and heirs, sometimes difficult. I know, everyone at holiday time, I'm sure everyone has the perfect family vacations and gatherings. Sometimes, though, those few people, not people but those few people may have some disagreements. So it's not always conducive to giving that information to family members. Privacy, I was mentioning about, that has become a very scarce or product right now. Everything seems to be public nowadays. Once you post it online, thousands of people can read it. Privacy has become an issue. And then at the end of the day, who do you trust to have that discussion with? Those are some of the roadblocks. Another thing to consider is this. We did a survey back in 2016. sorry, back in 2018. And what we did is we let them know that, there's a trillion, that is $1 trillion will be passed to the next generation between 2016 and 2026. That is an immense amount of money being transferred. In fact, one of the highest on record. So we've asked a number of questions, and I picked some of the best ones out here, or most interesting ones, I should say. And what we found out is 58% have not had a discussion with their heirs at all. Now, we didn't ask how in depth did you have the discussion about your estate. We just said, did you have a discussion? And almost 60% have not even had the discussion with their heirs. More interesting, 46% plan to, but that's like saying, I plan to go on vacation to Hawaii. You never book the flight and it never happens. More interesting is the ones that don't plan to have a discussion at all. 12% don't plan to have any discussion with anyone about the estate. So that's always a curious thing for me as to what are the family dynamics in that scenario. There are also concerns and barriers. So 32% worry about how their heirs were handed their inheritance. 28% do not trust their children's spouse to manage their inheritance, which is also very interesting. And then 20% worry heirs will have nothing left to pass on to the next following generation, that they're just going to blow the money. So these are very valid concerns. And again, the question comes about as to why don't people have that conversation beforehand? Why is communication so poor? And we've already looked at the emotional barriers to this discussion as a whole. It is one of the few taboo topics that still exist in society. There's also challenges with the state settlements. And this is a bit of a pain for the executors. You got to track down the current records and statements. That sometimes can be quite timely and, more importantly, costly, which the beneficiaries won't like. It's added stress of interpreting the will versus clear steps. And what I mean by that is the will gives at a very high level. Here's what we want done. Bobby gets 45%, Susie gets 45% of the assets, and then 10% goes to, friends and, maybe your favorite charity. But again, what it doesn't do is give the details of this. Oh, guys, I think one sec here, we got a little bit of a technical issue. One moment. Can I just get someone to say that you can see the presentation again?
We can see it.
Great, thank you. Okay, so the added stress of interpreting the will versus clear steps. So this is, again, the will is very high level on how things are distributed. They might have the percentages, et cetera, and some other additional detail, but it doesn't give the basics. There's so many little details in order to administer a estate, it may not have clear steps, and that may be left for the beneficiaries to interpret it. More importantly, the executor. There's the uncertainty of missing accounts or insurance policies. I'll talk a little bit about that in my own scenario as well. And then many different advisors knowing some of what your wishes are, but not one knowing everything. And so in that, having different institutions having different pieces of information, there's no real rhyme or reason, or no one really understands why things are where they are. If you were my father, one of the reasons you would have had GICs at different places, he'd had a small percentage of his money in GICs, but he would look for that, the free toaster when you signed up for your GIC, or whatever gift, or you get $50 extra for getting that GIC. So his GICs were a little bit all over the place. So there's various reasons as to why we did the things we did, but what I would recommend, especially for the executor, is have one institution having all the pieces and understanding the full process of what your wishes are when it comes to the administration of your estate. So define a strategy that you want. Not only can that help for clarity, but it may maximize the tax efficiency for the distribution of the estate. Getting tax receipts seems simple enough, right? I remember one institution, I had to request 7 times to get this tax receipt in order to complete the task. Just frustrating. Different institutions trying to get a simple thing as a tax receipt. Most importantly, you have one professional team that understands 100% of your family wishes. This can give great peace of mind when it comes to administering the estate on behalf of the beneficiaries. And then easing confidence of the estate settlement. You have peace of mind that things are being looked after. There is a plan in place and it's done in the best efforts and to your wishes. So let me share a little bit about my own experience now. So a little background. So my father emigrated from Austria as a young man, and my mother emigrated from England. And they ended up in this thriving town of Simcoe, Ontario. If anyone doesn't know where that is, it's kind of in the middle of the tobacco belt in Ontario. How they ended up there, I still don't know how they both ended up there, but very interesting. They fell in love, got married, started to raise a family on New Year's Eve, 1965. My mother was actually pregnant with myself. I was born in 66, and my dad needed a life-giving blood transfusion. And everything was successful with that blood transfusion. What my dad didn't know is that that blood was tainted with Hep C. And so he lived a very healthy life for over 40 years after that blood transfusion. But when at some point he got a hernia, had the operation, and his stomach had bloated out huge. And we joked because they had moved to Grand Bend, Ontario at that time, small little beach resort on Lake Huron. We joked about, the country doctor left the tool in there, you blew up, da da da. No one thought anything of it because we didn't know that the blood was tainted. Finally, after doing a number of things, they found out that the blood that he had received back in New Year's Eve 1965 was tainted. He was in stage 4, and he had a limited time on this planet. That's when I found out shortly after that I was the executor. No communication was done prior to that. And that's what usually happens with this. And this is one of the reasons I go about talking about it. It becomes a surprise. You pick one of your kids or you pick all your kids to be executors. How often do they do it? At the most kids, and this is the most popular thing, you do assign one of your children, you might do it once or twice in your life, your mother and your father. So you want to make sure that you have this conversation well in advance. The good part about this is that my dad knew he had limited time, so we started to plan for the estate. And so we did what another document that you'll be receiving from Big Financial is we started filling in this thing called the will companion. And what it is really is an estate directory. We call it a will companion because the will basically says, here's how we want things distributed, and a few other little nuances in it. The will companion basically says, here's where everything is, so that when it comes to administering the estate, you've got up-to-date information as the executor. And peace of mind, you're not wasting time looking for many things. It's a complete estate directory. Again, it's PDF fillable. I'll show you actually a document right here. This is kind of what it looks like. Again, being PDF fillable, if you've got chicken scratch writing like myself, very beneficial because you can type it out and then put it away thereafter. So an excellent document to have for sure, and perhaps a task that you guys could do while this pandemic is holding us a little bit more at home, something that yourselves could take the time to complete. And then probably on every so often, your advisor will remind you to fill it out thereafter and make sure it's up to date. But we filled out this will companion and started documenting all the pieces. And when it came to one piece, it was a bit of a difficult conversation. I don't know about yourselves, but I grew up in a very typical European family where finances was not something to be discussed. It was something that everything's good, you don't have to know, et cetera, et cetera. So my dad had this hidden safe. He was pretty savvy. He put a 250-pound safe up in the basement ceiling of where we lived in Grand Bend. My mom, I haven't told you this, but she has MS. She never goes to the basement. She didn't know what the safety box code was. Neither did I. So I asked my dad, "What's the combination?" And he's like, "Well, why do you have to know this?" That's my Austrian accent. If you're wondering what accent that was, my attempt at Austrian accent. And basically, what we did with that is we understood that this was going to be a little bit difficult. My dad had never talked about finances with us. And even though he was very proud and understood that the importance of getting that information, it was very hard for him. So, what do you do in Austria when things get tough? Whether you're sick, whether you have a tough conversation, you bring out the schnapps. So we brought out the moonshine schnapps that my dad had brought over 3 years prior. Huge 4 bottles of this moonshine schnapps that somehow he got across the border. We popped it out. He only needed a couple shots because he was highly medicated at that time. And we started having the conversation. And we joke about, look, what are we going to do here? Because we have two choices. I have two other brothers. The three of us boys could go down to the riverbank, blow the safe up, or you could give me that information. And so eventually, after we laughed a little bit, I finally got the combination. But these are the scenarios that we run into, little hangups here and there, things that were never discussed before just because it wasn't considered proper. Now we got the information. So we documented all that information. Now, before I documented all that information, as my dad felt he was the most interesting man in the world, we had to get off the internet. And what we did is we took the Will Companion, started typing up all the information. I typed up printed 2 copies, one for myself, one for my parents. Kept that in a file. I kept mine in my file, deleted it, and then you could put the internet back on. He didn't trust technology whatsoever. There's different ways to go about doing it. There's different ways to go about getting what I would say, what do you call it? For everyone to agree to it and how it's supposed to be done. But again, the importance of doing a will companion, I cannot stress how important that is because it is so difficult to find documents, know where everything is if you haven't put a will companion or a state directory together, and make sure that it's up to date as well. I mentioned in this also, I talk a little bit about what is called the surprise GIC. And that surprise GIC was, I was able to track everything. And again, as I said, we were able to plan ahead for a lot of this stuff. But there was one GIC I just couldn't track. I won't say what the institution was, but we had enough stuff to say, okay, I see the GIC, but I don't know where it went after that. We joked about maybe my dad had a girl on the side, but maybe he did. But we had to find out what the answer was. So we went to the different institutions. And just as another share for yourselves, I did not probate the will because as we planned this, I pretty much put everything in joint with my mom. Anything that was not joint, we made sure it was put in joint before my father passed away. So it was going to be a very simple estate to administer. But when I went to the institution, and clearly on the will it said that I was the executor, but because I didn't probate it, that first institution that I went to, that first branch, did not recognize me as the as the executor. Even though I was in my suit and I was all professional, I thought it was going to be a piece of cake. This was one place that said, no, we don't recognize you as the executor. So what do? Well, a block thereafter, there was another branch from the same institution, and I went into that. And they did recognize me, and this is what I mean by there's no consistency among the different financial institutions. Each one does it slightly different. It's more about the comfort level of the branch manager and the rules in those branches. This one recognized me as the executor. And so we sat down, and lo and behold, they said, no, that GIC is no longer active. And I could have left it at that, everyone, but I didn't because there was still something in my head. The teller did not actually lie. That was the truth of the matter. The GIC was not active. But like billions of dollars that are floating around in the States, what happens to a GIC when you've got it as automatic renewal? Well, it automatically renews. And so that GIC particular certificate was not active. It had renewed, and that teller did not go to the effort to say, we have renewed it. So because it didn't sit well with me and my mother, we did go to her local institution there, and we basically said, look, I'm having a real hard time here. It's saying that it's not active. We can't trace where the money is. I'm pretty sure my dad was not having a girl on the side. So what do we do here? So finally sat down with the assistant manager, and sure enough, they had said that this was renewed. But this is something to keep in mind, guys. There are literally billions of dollars in the United States right now that are just being renewed. The institutions can still loan out that money because it was not claimed. It was just an automatic renewal because there was no planning done in advance. So something to keep in mind, maybe to motivate that idea that could help some of your loved ones or favorite charities if that's what you intended to do on the estate. And then finally, I've got closure of estate here. And very quickly, we had to reopen the estate because there was money that had come in. So just again, no big deal. A year later, after I had actually closed the estate, additional money came in, and all I had to do, that was in my father's name, we basically opened up an estate account, transferred that to my mom, and we were able to close it. But again, those are things that pop out. That was a good thing, but sometimes negative things can pop up as the executor as well, and you have to deal with that. Finally, just to note again, Big Financial does have the will companion available for yourselves to utilize that, again, in PDF form if you got terrible writing like myself. They also have what I mentioned also, the executor duty checklist, which is a really detailed accountability of who's doing what in the estate, especially if the beneficiaries ask what's been done or any other legal entity. Here's the big challenge to yourselves for those of you who are listening. And this is, I'm going to challenge each of you to make a call to your financial advisor and start having the estate planning discussion. It doesn't cost a dime to have this discussion, ladies and gentlemen. It just takes a little bit of time, but that peace of mind that it can create for not only yourselves, but your loved ones, I think is so important. And so if any of this has motivated you to start getting a little bit organized in your estates on the initial steps, please do so. It's very important. And again, nothing like peace of mind when you're dealing with family items and even businesses and farms. So on that note, I will open it up to Q&A and ask that the other big financial advisors join me, and we'll see if we can answer some of your questions.
Thank you so much, Andrew. Really appreciate that. So there are a couple things to just mention. At the top of your screen, there should be a box there that allows you to open up the chat, so you can type your question there. Or there's also, if you have the app, a little hand that you can raise your hand, and we can look at that. Alternatively, jot your question down, and we would be happy to personalize that back for you. I mean, really today, the purpose is, first of all, we're hoping that you do have a will done. You've got your powers of attorney and the wills are done. The next thing is if you can communicate with us and let us know, where is the will? Where is it stored? If you have an executor already named and the will is in the safety deposit box, we want to have a conversation with you about the pitfalls of that. You know, I can speak on behalf of my colleagues that the number one thing that that parents want to know is that their kids are still going to talk, you know, when they're gone at Thanksgiving dinner. And so the key to that is obviously the communication. Andrew alluded to the paper that was done on intergenerational wealth transfer. So we want to know that this conversation is happening, and we are happy to broker that conversation between you and your executors to get that going. I see that there's a note in the chat that they've used the Will Companion and they find it an excellent tool. One of our very valued guests today as well is Andrew Pringle, who has kindly joined us today, represents a legal firm here in Ancaster. And I think that if there were a few questions, he would be happy to jump in. At the end of the day, we want to talk to you about the fact that you basically have three beneficiaries of your estate. You've got the people that you want to inherit the money, you have the CRA, and you have potentially a charity. So our job is to help you pick the two out of the best three out of those. So let me just have a peek here. So one of the questions that we've got here is, what is the difference to leaving a named beneficiary or leaving it as an estate? So perhaps, Andrew, if you wouldn't mind unmiking yourself, and then I'll start going through the questions from there.
Can you hear me? Okay. You can't leave something to an estate. That's you have to leave things to somebody. If you just designate your estate, it's not gone anywhere. It's still sitting there. So you do have to name individuals or charities or somebody. You can't just say estate. That's just left it where it is and it hasn't gone anywhere. There's a few things I could touch on with what the other Andrew said, but his story about the problem he was having with the financial institution bothers me, because the best thing about our banks is that they're big. The worst thing about our banks is that they're big. They're bureaucratic. They move people around, so the expertise that might develop in a branch because somebody dealt with an estate or dealt with a power of attorney disappears because they go elsewhere. People are afraid to make decisions because they might get their hands slapped by somebody up the chain of command. They don't understand things. It's just, for all these reasons, it's outrageous, the stories I hear when it comes to people dealing with banks and estates and wills and powers of attorney. And I have no magic solution or words that you can use, but it bothers me because here you are, you may be dealing with a spouse or parents that have died, you're grieving, and the banks are making it even more difficult. Like in Andrew's story, it's ridiculous that he had to go to multiple branches to finally get some help there. But like one of the worst stories I had, well, I don't know it's the worst story, but somebody says to me, the power of attorney you did, I took it into the bank and they said it's not worth the paper it's printed on. And I said, well, who said that to you? And they said, oh, the receptionist. I go, well, what does a receptionist at a branch know about what's a valid power of attorney? What'd they say? Oh, it didn't have the seal on it. You know, and I'm going, okay, here we go. When people want a copy of a power of attorney, what banks are often used to seeing is a notarized copy of it. And a notarized copy is, I attach, or a lawyer attaches a piece of paper to the power of attorney, a copy of it, and says, this is a true copy of the original. So this receptionist doesn't see that. They see the original power of attorney and think that that's somehow not good. Well, that should be even better than the notarized copy. But it's just an example of just an outrageous and incorrect thing that someone is being told at the bank. And I wish I had an answer to say, if you have this problem, this is what you do. But I'm frustrated with banks, but I wanted to sort of touch on Andrew's frustration with it as well.
Thanks, Andrew. There were a couple questions in the chat, but I also noticed that Jan had his hand up. Jan, would you like to remove yourself from mute and ask the question, please?
Can I talk? Do you hear me?
Go ahead.
Yeah. Someone asked, Ron asked, I am still confused when probate can be avoided. Can you expand upon this? I would like to avoid probate. We have one son, he is executor, and he would get everything. So that's all.
Andrew, do you have any ideas outside of the more expensive trusts that we could talk about?
Which Andrew?
I know I'm like, oh.
Andrew Pringle.
All right, I'll try. Well, keep in mind what the other Andrew said about when probate is required. Like typically real estate, if you own real estate, there are some exceptions if you've got parents, for example, that have owned property for a long period of time, without getting into the technicalities of it, you may be able to avoid probate in that case. But otherwise, if you own real estate that without joint ownership, that requires probate. If you have amounts, like the other Andrew said, in bank accounts or in banks, financial institutions, investment firms, that requires probate when you're over these threshold amounts that are typically measured in the tens of thousands of dollars. So those are the things, if you really want to avoid probate, that you have to avoid, is having a lot of money in your own name in financial institutions, including banks, or you own property jointly with others. And yeah, probate's a bit of a pain in the ass, but as the other Andrew points out, it's roughly 1.5% of the value of your estate. It's not a gigantic number. It's not like income taxes and capital gains taxes. It's a small number. And it's not like, don't be doing huge amounts of planning to avoid it that might open up other cans of worms. So you go, oh, I'm going to put all my kids on my house with me, or I'm going to put all my kids on my bank account. Well, you've now lost control of that asset. Maybe you got a kid that's irresponsible. They're taking money out of your bank account. They've declared bankruptcy. Now that's an asset. Your bank account can be used to satisfy creditors. So, to avoid probate, you may create other problems. So, be aware of things you can do. And the other, like giving away your money in your lifetime. If there's no tax on gifting money or anything to a kid. So, that's a way. But again, general rules: don't own real estate solely, and own smaller amounts of cash and investments in financial institutions. But again, be careful of what you're doing.
Thanks, Andrew. One of the questions on the chat group was about the downside to having accounts and property in joint trusts. So that I think you have answered that. One of the things that you sometimes also talk to is that if your sole inheritor is also married and you have joint, then those assets could be exposed to any matrimonial breakdown as well. I think you've mentioned that to us in the past.
Can I talk on that point? Because there's another point Andrew had on a slide early on is avoiding this. If when spouses separate in Ontario, there's something called an equalization of net family property, which means everything they've accumulated in the time they've been married gets split between the two of them. It can be a very complicated thing, and there's family lawyers help you work through it. It can be very complicated, but simplistically, that's what it is. The Family Law Act will say an inheritance is excluded from that calculation. So you get that benefit. Most lawyers will add a clause that says not only is the inheritance excluded, but so is any income that it generates. So, sort of a simple, easy math example that I use is, if you leave $1 million to your child, they then take that money and they invest it, and it sort of magically earns 10% a year every year for 10 years. So it's now worth $2 million. Then they separate. That entire $2 million is the other spouse can't touch. $1 million because of what the Family Law Act says it was an inheritance, and the other $1 million, $100,000, 10% every year for 10 years, is excluded because of the clause that the lawyer can put into the will. It is important if for kids, it's nothing you can do in your will, but to tell your kids, take my inheritance, put it into a separate bank account or separate investment, so that's not got your spouse on it, just to make it clear that it doesn't get intermingled. It's easy to spot and identify that if you separate, that's the asset, and any income it generates, the spouse can't get at that.
Thanks for the clarification. We probably just only have a couple more minutes left, but be looking at the chat line. I don't see anything else coming up. So I think what we would want to do then in conclusion, unless somebody else raises their hand, is we will be in touch with you. If you forwarded the link, for example, to one of the members of your family, please feel free to send us the names so that we can make sure that those materials are sent. We have the Fillable Will Companion and the Executor Connect. We would welcome the opportunity to have a conversation with you and your executors to get this conversation going and change that percentage of that 58% that have not discussed their intent with their family. Again, from all of the advisors here, we've got one question. Is the principal residence subject to probate? I think I can answer this, but I'll let Andrew Pringle speak up again, please.
Principal residence is exempt from capital gains, which is the bigger one. So you avoid that big tax, but there's no exemption for the probate fees or estate administration tax. The one thing you can deduct from it is if you have a mortgage on it, you can deduct that. So if you have a $1 million house, but a $500,000 mortgage on it, then the house is valued for probate purposes at $500,000, and you're paying the probate fees on that. But whether it's a principal residence, it's investment property, rental property, a cottage, they all have to be included for probate purposes and pay the estate administration tax.
That's great. Thank you. We had one hand up from Robert. Would you mind unmuting yourself and asking the question, please?
Yes. Hello. Can you hear me?
Yes. Thank you.
If you have named a beneficiary to your principal residence for your house, you've basically, let's say you've willed your house to your son, and after the will is written, what happens is maybe you become unable and you go to a retirement home and you end up selling your house. How does that affect the will? What will the son then inherit? Is that inheritance gone?
Yeah, the inheritance is gone. The gift fails because it doesn't exist anymore. It'd be the same for anything. I mean, if you say, "Oh, I'm leaving my wedding ring to my daughter," and you gave your wedding ring to your daughter or to somebody else, and it doesn't, so you don't have it anymore. Your date of death, the gift fails.
I think that's a really good question, because it really shows the importance of having legal advice and getting a properly drafted will so that your intent and communication is clear. Okay, so I think that we will wrap it up there. Again, on behalf of all of the advisors at the BIC advisors in IPC Securities, thank you, Andrew Schradel, for your presentation as always. Thank you, Andrew Pringle, for joining us today. And feel free to reach out to your advisors so that we can answer any follow-up questions. Thanks, and have a great day.
Thank you.
Thank you.
Thank you, everyone. It was awesome.
Hey, Murray, you still there?
Hi, Jan. I'm still here. You are still being recorded. If you'd like, I can call you after, or please feel free to ask a question.
Now or